Hi, my name is Hilary Cragg and I'm a solicitor with Nash and Solicitors, and I specialise in supporting people with dementia, amongst other things. I'm here today to talk to you about powers of attorney. Excuse me, I do have some slides which I will share with you, so that's why I'm referring to my slides. So if you are thinking about doing some powers of attorney or trying to get your affairs in order in any way, one of the first things that I would do is think about what you want to happen, think about what you want your future to look like, create obviously powers of attorney, and I'm going to talk about that in quite a lot more detail. Talk to your family. Talk to your family and friends. What do you want your future to look like? What do you want it to include? And if you feel really strongly about things that you don't want it to include, what does that picture look like? And then get your paperwork sorted. One of the things that's really helpful is actually having things like your utility bills or your council tax or anything that you have in paperwork, your bank statements, into a nice neat file where they can be easily accessed, because if somebody has to look at that information and find it, it's much easier if it's nicely organised. So I'm going to now talk about powers of attorney, but before I go into detail about the different kinds of power of attorney, I'm going to talk about powers of attorney in general, because there are two kinds, and this is true for both of those kinds of powers of attorney. So you can have up to 5 attorneys, and you can also have substitute attorneys. So your attorney would be your attorney of first instance, and your substitute attorney is not your attorney until such time as something happens to your attorneys in first instance. So they can also be what's known as joint or joint and several, and those phrases mean nothing. So joint means all attorneys must make the decision together, and there has to be unanimous agreement. Joint and several means that any one of the attorneys can make a decision, that you don't have to have full agreement. There are some real issues if one attorney says do this one thing and the attorney says do the other thing, and then attorney number one comes in and goes no, do the first thing, because then you haven't got a consistent decision maker with what's going on. There is also a hybrid, so there's a box in the form that says what happens if you want to do something slightly different, that's some really big important decisions you want to be made jointly, and other smaller decisions need to be made joint and several, and that's fine. There is a special box for that. What you need to be very clear is which decisions are being made jointly. So that might be the sale of your property or life-sustaining decisions about a treatment for life-sustaining treatment. But it could be anything you want. Any transaction over £5,000 or £10,000 requires joint approval of your attorneys. One of the problems about appointing joint attorneys is if one of them is away on holiday, if one of them becomes very ill, or if one of them dies, you still need all of your attorneys to agree. So if you've got substitute attorneys, then your substitute attorney would come in. But if one of your attorneys dies, then the whole power of attorney fails. So you need to think very carefully about what decisions you want to be made jointly. Your substitute attorney comes in when there is what's known as a terminating event. Now, a terminating event, which is for your attorney in first instance, happens if that attorney dies. If you are married to the attorney and you divorce them, then that would be considered a terminating event. They can do what's known as disclaim, which means they're saying, I don't want to be attorney anymore. Or if they're a financial attorney, if your attorney is made bankrupt, that is a terminating event and they would cease to be an attorney for you. So there is no priority between your attorneys. There's no, the oldest child is the more important attorney, and that's the primary decision maker. There is no primary decision maker. There is no priority of attorney. They are all equal and they're all equally able to make a decision, including spouse. So if you've got your spouse and your children as your attorneys, the spouse isn't a primary attorney. Everybody is equally able to make a decision. Those decisions made by an attorney are binding. So if the person makes a decision themselves, they that decision for themselves is binding, and the attorney making the decision is equally binding. So when the power of attorney is made, the donor, that's the person who makes the power of attorney, must have the mental capacity to do that at the time of signing. Doesn't matter if they lose that capacity later on, but at the time of signing the document, they must understand that the document they are signing and that is their power of attorney. And within the document, there is a role that's known as certificate provider. And when somebody goes to see a solicitor or a professional to create these documents, that would be the role that the solicitor acts as. And they are confirming that at the time of signing, this person understood the document that they were signing, that there was no fraud or undue influence, and that everything was fine with the creation of that document and that power. There are a very small number of decisions that an attorney cannot make. There aren't many of them, but they are quite important decisions. So one of them is an attorney cannot make a decision to marry, for the donor to marry. They cannot make a decision for the donor to get divorced. Sometimes it happens that the spouse of somebody who's unable to make a decision chooses to divorce them, and in which case then the attorney can deal with the financial consequences of the other spouse's decision to divorce, but an attorney cannot make a decision about divorce. The attorney cannot make a decision for the donor to have sex. Only the donor themselves can consent to that. Nobody else can consent to somebody having sex. And then there's another decision around access to visitors, which sometimes a judge can actually make that decision, but the attorney can't make that decision. And that's to prevent people from coming to visit the donor of the power of attorney. And sometimes it's necessary to create some boundaries around that without being full restrictions. This person can never come to visit. So, for example, if the donor of the power of attorney gets very anxious around lots of people, then it would be perfectly reasonable for the attorney to say only 2 people can come and visit, and maybe only for 20 minutes or half an hour or an hour, whatever's the right thing. So they can have a few restrictions in there that are the right thing for that particular person. But what they can't do is say this person or this family member can never come and visit. They can't put on those full blanket restrictions like that. However, a judge can. So if that is necessary, then you can always apply to the Court of Protection and the judge can make that decision. It may also be a safeguarding issue, and the local authority have some powers around full restriction and not telling people where somebody is. If, for example, they were the victim of domestic abuse, it may be that their domestic abuse spouse doesn't know, or their domestic abuse family member doesn't know where they are. But that would be, in part, a local authority safeguarding decision. So within the power of attorney document, there is a box that's marked instructions. And this is something that you would fill in, and this absolutely must happen or must not happen, depending on whether you've written it in the positive or negative. You need to be very careful around writing things in this box, because if you've written something to say you must not sell my house, and then it becomes necessary to sell your house, you then need to apply to the Court of Protection, or your attorneys would need to apply to the Court of Protection for an order to sell your house, which is very complex, very time consuming, and usually very expensive. So there is another box that's called preferences, which I'm going to come on to talk about in a moment. And anything that might need to be overreached is better in there. But something that's in instructions is something that must happen or must not happen, depending on how it's written. Then you've got the preferences box, and this can include things that you might quite like to have, but they're sufficiently important to you that you want to include them. And this is a great way to think about how you would want to spend your day. What is it in any one particular day that takes an ordinary, everyday, fairly boring, ordinary day to making it into a really, really great day. Those days that memories are made of. So what is it that is included in a really great day? It might be things like contact with family and friends. It might be that you want to be with your dog. It could be that you really love chocolate. It could be that you love a glass of red wine. You can input anything that you want in there. Sometimes some of these things need to get adapted a little bit. If you say you really love red wine, for example, but then you become dependent on medication that alcohol's counterindicated, maybe you have alcohol-free wine, for example. Or if you love football and you want to go to the football stadium, as time progresses, that might become really difficult. So instead of going to the stadium, you actually just get a Sky subscription and you watch it on the TV instead. So these things can be adapted, but what is it that brings you happiness, that makes your day a really great day? You can include this in the preferences. So some important ones are, I want to stay at home, I want to be with my spouse, and then anything that you want, and you can include as much or as little as you want in there. But they're really helpful to protect the things that are really important for you. Often they're things that your family would know about, but it's when you go to an environment where they don't know you quite so well, and then these things are written down for you, and then it makes it easier to make sure that you keep these things. So coming on to the two different kinds of power of attorney, there's a financial one and a health and welfare one. They can't be used unregistered, so they have to be sent to the Office of the Public Guardian, which is also known as the OPG. The OPG in the UK or in England and Wales is the body, the organisation, the government organisation that has a few statutory powers, one of which is to hold the Register of Powers of Attorney. They can also do some investigations, and I'll come on to that later on. So they have to be registered at the Office of the Public Guardian, and that costs £82 per lasting power of attorney. And if you are of low financial means, then there is a fee exemption process if you receive any of the means tested benefits, or if you have low assets, then there is a process for a reduced fee. But without that, then they still have to be paid for at £82. The process of registration currently takes about 4 to 5 months, so it is quite time consuming. So the financial power of attorney, it covers all financial assets, everything that person owns. It covers all the things of intrinsic value. So the house, your enormous savings in the bank, or modest savings if they're modest. But it also includes the things that are of low intrinsic value, but of high sentimental value to your family. And therefore they can be equally important. So it might be things like your wedding ring. So your wedding ring is worth a lot less money than your house. But if it's really important to your family, then this becomes of really high value. So it covers all of that, covers everything that you own. It can be used before the donor has lost mental capacity. Now, sometimes people have some physical impairments, which makes it difficult for them to run their own errands. It's difficult to get to the bank. It's difficult to manage their grocery shopping. So they want someone else to do that for them, but it doesn't mean that they can't look at their bank statement and say to their family member, I said for you to get me out £20 from the cash point. Why is there £50 here that you've taken out? What happened to that other 30 quid? Talk to me about that. So when an attorney makes a decision, if the person lacks capacity, they must make a decision in that person's best interest. Now, the attorney might think, I know mum needs 30 quid now, but she's going to need 20 quid next week, so I'm going to get 50 quid out instead because I don't want to have to go back to the cash point. They're able to make their own decision if the donor has lost capacity. But if the donor has capacity, all they've got authority for is to follow the instructions of the donor. So that's where the donor is able to look at their bank statement and question what's going on. One of the things that a donor can do is anything that one of the things that an attorney can do is anything that the donor can do. So they can open a bank account, close a bank account, move investments, sell property, buy another property, anything that person can do with their own assets. The one exception is they cannot make significant gifts. So they can make small, modest gifts. If somebody gave every family member 20 quid at Christmas or 50 quid at Christmas, then they can continue to do that. What they're not able to do is go, but I'm the favourite child, so instead of 50 quid this year, I'm going to give myself £10,000. That's a significant gift, and then they have no authority to do that. And in the legislation is very clear that the gifts must be affordable and mindful of the size of the estate. So even somebody with a very modest estate, maybe the gift at Christmas is £5, and that would be fine. It just can't be a large sum of money, and it also has to be what's known as on occasion. So you can't have a Christmas gift that's given in July. So Christmas presents come at December. Birthday presents would be on somebody's birthday. Graduation would be in the summer. So it needs to be for a specific occasion and not just because I'm in the mood to have some money or give some money away. There are health and welfare powers of attorney, and this covers both medical and social care decisions. Most people kind of understand what a medical decision is. They're talking to a doctor, a nurse, a paramedic, somebody with a healthcare profession, and that person, that healthcare professional, is explaining to them that they have a specific health issue and that there is potentially various courses of action that can be taken. Now, it is a medical decision what the response is. So if you have medical problem A and course of treatment B, C or D as your options, what options are offered is a medical decision. But once they're offered, it's then an attorney decision as to what gets taken up or not. So it could be you've got medical condition A and your possible responses are B, C or D, or nothing at all. The attorney might decide to do nothing at all. Now, the difference between the financial one and the health and welfare one is that these decisions can only be made if that person lacks capacity to make the decision themselves. Otherwise, it's a decision for the donor and it's not a decision for the attorney to make. But it could be any form of treatment, it could be medication, it could be any form of therapy, it could be surgery, it could be anything to do with their medication, anything medical at all. As long as the donor lacks capacity, the attorney is then able to make the decision. The power of attorney also covers welfare decisions, and these are actually really important to quality of life. So these would be social care decisions, which includes things like what you wear, very importantly where you live, which is whether or not you go into a care home or whether you stay in your own home, what you eat, how you spend your day, what programs you watch on the telly, what music you listen to, whether you go out and go into the community and go to the groups that you always went to, whether or not you're still part of your knitting group or your football group or whatever it is that you want to do with your time. They are really important and cover your personal care, your residence, food, fluid, whether you have your red wine, as we've already discussed. In the power of attorney for health and welfare, there is also a separate question regarding life-sustaining treatment. And people who have a terminal diagnosis quite often ask, they're really curious. They tend to be really curious about three things. So, how long have I got? What will that look like as my condition progresses, and will it hurt? So this is somebody if they have a terminal diagnosis. However, sometimes you might not have a terminal diagnosis. You might have an accident and then just simply be told you've got a couple of hours left. The whole will it hurt is probably relevant to that one though. So life-sustaining decisions can be made in any of those circumstances. At this point in time, assisted dying is currently unlawful in this country, and I know there's some legislation that's going to look to get that changed potentially. However, it is unlikely to ever, and certainly not within the current legislation, to be relevant for people with dementia. So where assisted dying is lawful, you have to have the capacity to consent to it. So for anybody who has dementia and is no longer able to consent to it, assisted dying will always remain unlawful, and that probably is never really going to change. With the question about life-sustaining treatment, what the attorney cannot do is make a decision that will bring about the death of the attorney, of the donor. An end-of-life decision is made in the circumstance where that person, the donor of the power of attorney, is very, very unwell and death is imminent of its own. Nobody has made this decision. They have just got a medical condition that means that death is imminent. And then a decision needs to be made whether or not to intervene or just to let death take its natural course. And that's what the decision is about, is whether or not death just takes its natural course or whether somebody intervenes and prevents death from happening. So it is not assisted dying. It is a question of allowing death to happen or intervening. In the power of attorney, you can allow your attorney to make a decision about life-sustaining treatment or not. And then even if you said no, they can't make decisions about life-sustaining treatment, they can still make decisions about every other aspect of your care. Life-sustaining treatment could be decisions about whether somebody has antibiotics. It could be decisions about whether they go to hospital. It could be decisions about whether or not they have food or fluid. It could be CPR. One of the things is refusing CPR as well. So there are lots of kinds of decisions that are involving life-sustaining treatment. And there is a question in the power of attorney that allows the decision to be made by the attorney. There are some quite common misconceptions about powers of attorney. And I'm going to talk about those next. So one of them is that powers of attorney can only be used when the donor has lost capacity. That's not true. Sometimes the donor, as I said, can have some physical health problems, which means that running their errands becomes quite difficult, but they're perfectly capacitated and they just want someone to do that for them. That's fine. Power of attorney works well for that. Lasting powers of attorney are really expensive and really complicated. Actually, that's not true. The boxes are quite factual in lots of cases. So what's the name of the donor of the power of attorney? What's the name of the attorneys? What's their address? What's their date of birth? These are very factual questions and they're not complicated. The forms can be quite long, but you just have to go through them slowly. And said the registration fee is £82 per LPA, and if you are of low financial means, then there is a fee exemption process. I get people talk to me and saying, well, I only need one power of attorney. It's usually the financial one that they think that they need. And that's because somebody's tried to go to the bank for the donor. It's quite often children go to the bank and say, mum or dad has had this bill that needs to be paid. The bank aren't going to give them access to it. And so something has to be done in order that their bills get paid. And that's the power of attorney. But the health and welfare one is also really important. So this allows that person to make decisions about what their quality of life looks like when they become much more unwell, and when they're impaired, they're still able to make sure that the things that they enjoy the most are preserved for them. So they don't just need one power of attorney, they need them both. The powers of attorney are about giving control to somebody else, that they're giving their power away. What they are giving is an authority to make decisions on their behalf. But what they're able to do, particularly if they use the preferences and instructions boxes, is make it really clear what they want their quality of life to look like. So actually, it's not giving power away, it's actually preserving power back and saying, these are the things that are important to me, these are the things I want to keep. And these are the people that I trust. One of the questions that I do talk to families about is, do you trust your attorneys? If the answer is yes, that's fine, appoint them. If the answer is no, don't appoint them, because they have such a big amount of control over your life. If you're not sure that you trust them, don't appoint them. They are really powerful, these powers of attorney documents, and you shouldn't be giving them to somebody that you're not sure is going to do the right thing for you. You can't change your mind if you have a power of attorney. That's not true. That's another common misconception. You can change your mind. It's absolutely fine. So if you have a falling out with your attorney, whether it's a family member or a friend who's your attorney, that's fine. You can cancel it and change your mind. As long as you're cognitively able, you can cancel that power of attorney at any point in time. If you lose capacity, it's then only the Court of Protection that can cancel that power of attorney. This idea of next of kin, I don't need a power of attorney because I've got a next of kin. That's a common misconception. The next of kin isn't a status that the bank would recognise, and so your financial matters wouldn't work. Also, medical professionals will not take a next of kin decision as the decision. Now, under the Mental Capacity Act, they have a duty to consult. So healthcare professionals would consult with family, but they are the decision makers until there is a power of attorney in place, and then it's the attorney that is the decision maker. But it's not because they're next of kin, it's because they're attorney. The next of kin has no decision-making ability. The LPAs are only for the elderly, that you don't need it if you're younger. That's not true. As long as you're over the age of 18 and as long as your attorneys are over the age of 18, anybody can have a power of attorney, because you could have an accident and need a power of attorney at any point in your life. That medical decisions are made by the medical professionals, and so it doesn't matter anyway. If there is no power of attorney in place, the medical professionals, the health and social care system will make decisions on that person's behalf. That's absolutely true. But if you want to make sure that your decisions are made in consultation with health and social care professionals, but by people who know you and love you and will follow the things that you want, even if it involves a degree of risk, then it's the attorney who would make that decision, not the health and social care professionals, and the decision is binding by the attorneys. And that best decision meetings are decisions that are made by the healthcare professionals and not the attorneys. Sometimes there are some important decisions that are made with what's known as the best interest decision meeting. So there's a big meeting that would involve health and social care professionals, and where there's an attorney in place, at the end of that process, the attorney is the decision maker. Otherwise, there's the best interests meeting process, and it will be a health and social care professional who would be the decision maker. So those are really important moments in which the power of attorney becomes really relevant. So those are the misconceptions. Things can go wrong with powers of attorney. So, as I said, you put a huge amount of control in the hands of your attorney, and then if you have a change in your relationship and you fall out with them, then there are real problems, or if they turn out to be untrustworthy. It is entirely possible that they can steal from you. It's entirely possible that they can neglect you, so they can leave you without adequate care. They are breaching their duty, but it doesn't mean that it's impossible to do, which is why I come back to this very important point. If you're going to appoint somebody to be your attorney, you must trust them. They have an immense amount of control over your life. There are both statute and some statutory guidance that says what your attorney should do and how they can behave, but attorneys can breach them. Most of the time they don't. Most of the time attorneys are fine. They do a brilliant job. They're supportive of their loved ones and their family members, and they are fantastic. So I'm not trying to be overly negative, but a certain small proportion do go wrong. So some of the things that can go wrong is where attorneys do what's known as things that are self-interested, and that's sometimes known as self-dealing. And anything that would be done that was self-dealing would require the approval of the Court of Protection. So that's, for example, if the attorney wants to buy the house that belongs to mum or dad, who is the donor of the power of attorney, they would need approval of the Court of Protection. That's known as self-dealing, even if they're buying it at market value. If they were buying it at market value and they can show the court that they were buying it at market value, there would be no reason that the court wouldn't approve that order, but they would have to apply to court. If they were taking some of mum or dad's money and investing it in their business, thinking mum or dad would want to support me, again, that's self-dealing. It would require approval from the Court of Protection. Attorneys can't pay themselves. So when you have a professional, such as myself, to act as attorney, we have to write into the power of attorney what's known as a charging clause, which says we are allowed to be paid for our professional services. But family members wouldn't write that in. And if solicitors forget to write it in, we can't charge for the work that we do. So they cannot be paid. So in the circumstances where somebody who was a professional working for them, like your gardener or your cleaner, they can't then, interestingly, they can't also then be paid to be a gardener or a cleaner. They can't be paid. So that, again, would require application to the Court of Protection. Sometimes things go wrong because if you've got more than one attorney, the attorneys just don't get on with each other. They just row with each other. And if one attorney says the sky is blue, the other one will go, no, it's green. And they just don't get on. And that can create real problems for the donor because they're just thinking about their own row between the two of them. But that creates real problems when attorneys don't get on. Attorneys can steal. Truthfully, most of them don't in reality, but absolutely they can steal, and they can steal big chunks of money if they really put their mind to it. Potentially, there are lots of different kinds of consequences to that. The attorney can also just neglect the person. So if that person needs care to come in and help look after them, and they just don't bother arranging the carers, so the person ends up very neglected. They might be malnourished, not taking their medication, in a very poor state of health. They can do all of those things. So what happens when something goes wrong and one of those awful things happens. The self-dealing is relatively easy to deal with because that's an application to the court. The rest of it can be a little bit more complicated. One of the first things to do is speak to the donor and find out what they want to do about it. If one of the things that makes this complicated is it's often family members who are the attorneys. So if you've got a parent and the child has stolen £100,000 and spent a whole load of it, actually that parent might not want them to go to prison because this is still their child. So maybe the best outcome for them is that they just get £80,000 back and change the power of attorney. But for that person, that's the best outcome that they can achieve. These may be circumstances where we are looking at the least worst outcome because there is no good outcome. So very importantly, empower the donor. What do they want to do about this? You can report the matter to the Office of the Public Guardian, so also known as the OPG, and they have a safeguarding department and they have powers to investigate. And I'll come on and talk about the OPG investigations in a minute. You can report the matter to the local authority. The local authority have some statutory safeguarding duties. They would also liaise with the Office of the Public Guardian. Because obviously the Office of the Public Guardian have jurisdiction over attorneys, and the local authority would hand that off to the Office of the Public Guardian, and then the local authority have some other obligations to people in their community to make sure that they're safe and cared for. So it might be that some of the statutory local authority safeguarding requirements are needed in there. You can also report them to the police if there's violence involved, or if there's a criminality involved. It may be that you report them to police. That might be the right outcome. But importantly, start with the donor. What do they want? What's the outcome that they're looking for, the best one that they think they can achieve? So when things go wrong, as I said, the Office of the Public Guardian then investigate. And part of their function is to supervise and investigate the behaviour of attorneys. So these investigations from the Office of the Public Guardian, they usually take place where the donor of the power of attorney has then subsequently lost capacity, so they're not able to deal with this themselves, and that's where the OPG are able to then step in and make this investigation. These investigations are very thorough. They're very long. They take weeks. Usually a standard one would be 18 weeks, but sometimes they can take even longer. I've been involved in some of them that have been 8, 9, 10 months long. They will ask for lots of documentation, and it depends in part how cooperative the attorney is in providing the information. They can send along somebody that's known as either a visitor or a special visitor. So special visitors tend to have extra qualifications. One of the things that they will do is look at that person and think, this transaction happened 6 months ago. Did they have capacity 6 months ago to make that decision? And that's usually done by a special visitor who would be a consultant psychiatrist, and that consultant psychiatrist would then also look at medical records so that they could make a retrospective decision. It might be that there's a visitor, and there are a number of different kinds of qualifications for people who are visitor. They might be private social workers, they might be private nurses, but they are specialised in the work of being court of protection visitors. And they would then speak to the attorney. Potentially they would obviously see the donor of the power of attorney as well, and they would look at what's been going on and ask different questions, look at paperwork. So these are long and thorough investigations, and it all depends on what's being investigated, but it could be a health and welfare matter or it could be a financial matter. Once the OPG have finished their investigations, they come to one of three conclusions. The first one is everything's absolutely fine, donor's amazing, and it can be that people make malicious complaints to the Office of the Public Guardian. And this is where you get these two powers of attorney that don't like, or two attorneys that don't like each other, and one of them is just trying to make life miserable for the other one. But once the OPG investigate, they might think, no, absolutely, the attorney's doing a really great job, they're fantastic, no criticism, no points of reference for things that they could improve. The second one is, they've got it mostly right, but actually there are a few things that they're not getting quite right, and what we need to do is give them a bit of guidance and make sure that going forward they change what they're doing and they get things a bit better, but mostly they're okay. And then the third option is, no, these attorneys are not doing a great job and they need to be removed. And at this point in time, the Office of the Public Guardian will then apply to the Court of Protection, which is the court that has jurisdiction for people who lack capacity, and they would have that attorney removed. One of the outcomes, therefore, is that the attorney would just do what's known as disclaim, which means cease to be an attorney. And that might be sufficient then to satisfy the Office of the Public Guardian, is that then this person is no longer attorney going forward. But they could still apply to the Court of Protection depending on what's happened. So if the attorney has stolen £100,000, then maybe they apply to the Court of Protection for an order to have that money reinstated, even if that person disclaims. So it all depends on what the decision is and what's going on. But when obviously there's an application to the court, then it's referred to a judge, and it will be the judge that makes the decision. And if the attorney thinks I haven't done anything wrong and I will stand in front of a judge and justify my decisions, that's their opportunity to do so. Both the Court of Protection and the Office of the Public Guardian only have jurisdiction for people who have capacity, the Court of Protection only has capacity, has jurisdiction for people who have capacity and are still alive. So if during an investigation the donor of the power of attorney dies, the investigation will cease and the Court of Protection no longer have jurisdiction, and it would be then dealt with by a different court. So what happens if the person has already lost a capacity and they can't do a power of attorney? Things have happened and it's gone too far. So you can apply to the Court of Protection to become that person's deputy. And from the functional point of view, when you go to the bank, it works in a very similar way. Paperwork is completely different, but from the functional point of view, it gives you access to the bank account, and you can deal with that person's money on their behalf. Going forward as a deputy rather than as attorney, you then have supervision from the Office of the Public Guardian, and you have to submit paperwork every single year to the Office of the Public Guardian to show how you've managed that person's funds. You also have to have a bond, and the Court of Protection will be the body that decides the level of the bond, and that works as an insurance product, so that if the deputy misappropriates the money, the bond will repay back to the donor the money, and then the bond company can try and recover the money. But if it's lost because it's either been spent or they've gone out of the jurisdiction, then that money is lost. But it protects the estate of the donor. Applications for financial deputy are now mostly done online. It's a process that takes quite a lot of paperwork. You have to provide a lot of information to the court, and then that ultimately will be shared with the Office of the Public Guardian so that that deputyship can be supervised. so that when the application is made to the court understands the extent of that person's estate, and they will then make the order to appoint that person as deputy. They will do a bankruptcy search to make sure that at the moment of appointment that person has no CCJs or is not bankrupt, and then they will appoint the deputy to act for that person and manage their affairs. That process of application to the court takes around 6 months if you do it online. If you do it by paper, sending into the court, it can take 9+ months to do, and the court fee is much more expensive. It's £431 as opposed to £82 for one power of attorney. So more time consuming, more costly, and you usually just get a deputyship order for financial affairs. Separate to that, there is a deputyship order for health and welfare. When an application in either circumstance goes into the court for financial affairs, the court will ask, why isn't appointeeship suitable? And appointeeship is what can be given by the DWP to manage that person's state benefits. So for somebody who has rented accommodation, particularly if it's social housing, and their income is state benefits, whether that's a pension or other state benefits, DWP appointeeship will allow somebody to access the bank account to deal with those state benefits. What it won't do is allow you to deal with non-state benefits. So you can't deal with property, and you can't deal with things like shares or investments. So for somebody with very limited means, then that might be sufficient, and you don't need to apply to the Court of Protection. An appointeeship is completely free. You just phone up the DWP, and they can grant it. There's an interview process to go to, but it's relatively straightforward. If somebody's financial affairs are more complicated than that, then that's when deputyship comes in. So as well as the financial one, there is a health and welfare deputyship order. And the first question that the court are going to ask is, why doesn't Section 5 of the Mental Capacity Act work? Now, what Section 5 says is that any health or social care professional can make a decision in that person's best interests. So why do we need a deputy? And they do refuse quite a few of the deputyship applications. You need to show the court that the proposed deputy either has to make lots of decisions or makes decisions that are more effective than the local authority, and that there are also lots of decisions. So it's usually where somebody is living in the community and they have a complex life that they would consider granting a health and welfare deputyship, but they are quite complicated, and you have to justify why the health and social care professionals are not making good enough decisions. So the Court of Protection, as I said, is the court who has jurisdiction for people who lack capacity. They deal with applications for self-dealing attorneys. They can deal with some matters quite urgently, and so they can deal with orders that are super urgent and you need a decision in a matter of a few hours, because that would be because something is life-threatening. That if that order isn't made within 2 or 3 hours, that person will die in all likelihood. So you can make very urgent applications. There are other applications that are fairly urgent, but not urgent within hours. So you would want the court to deal with that within a few days or weeks. If you want the court to deal with that in that sort of time frame, you need it to be clear within the time frame that you want it dealt with and why it's so urgent. Otherwise, it will just sit in a process that could take 9 to 12 months to be dealt with if it's considered to be non-urgent. So that would be things like making gifts or selling property, and the court wouldn't necessarily think that that's urgent, even if you think it is and it's got a buyer. The court tends not to see things urgent that can be dealt with that's just purely money, because assets still exist. So I think that's pretty much everything that I wanted to talk to you about. But if you do have further questions, then potentially go and seek some legal advice. But I hope that that was helpful and informative. Thank you very much for your time.